Hi, good afternoon, and welcome to the fifth Data Protection, Digital Transformation Thursday. And we're very pleased today to have a very interesting topic and a very esteemed roster of speakers. We have with us Dr. Clarice Giraud of the Asia Business Law Institute of Singapore, of the Singapore Academy of Law, to talk about data privacy trajectories and where we believe data privacy may be headed. And we also have the chairman of the National Privacy Commission, the inaugural chairman, um, the Honorable Raymond E. Liboro. Um, so I'll begin by introducing our first speaker. Our first speaker is Ms. Clarice Giraud. As I mentioned, she is the Data Privacy Project Lead of the Asia Business Law Institute. She's a graduate of the University of Paris too, with degrees in Public and Private Law Studies and a Master's in Intellectual Property Law. She's also a graduate of the University of Oxford with a Master's in Jurisprudence in European Comparative Law in 1995, where I understand she met a sitting member of the U.S. Supreme Court. Maybe more on that later. That was just a teaser.
Yeah.
She has worked in data privacy for many years, since 2000 as a senior legal counsel at the French Privacy and Data Protection Commission, and as head of the Department of EU and International Affairs up to 2008, and counselor to the president from 2009 to 2015. Welcome, Clarice. I will now share and now I've lost my, hold on. That's the problem when you're running the show. I lost my mouse. Okay. I'm not sharing anything, no? Okay, here we go. Where's my panel? Share screen. I'm gonna share your slides.
Oh.
Okay, it's this one. And then I don't think I need to, I think I need to put it back to the first slide. There, okay, there you go. Go ahead, Clarice, I'll give you control.
Okay, thanks so much,
Right.
JJ. Hello, everyone. It's a pleasure and honor to be with you today with JJ, who I met when I arrived in Asia 5 years ago and has become a great friend, and with Commissioner Liboro, who I've had the great pleasure and honor to work with over the past years. So when we discussed, this presentation with JJ over the past weeks, we thought we would, it's basically we've had free reign with Commissioner Liboro and myself to discuss, the trajectories of data protection and privacy. Over the coming years, what's in there for the Philippines, in ASEAN generally, what's for you, privacy professionals, in data protection in the coming years. And we thought, actually, thinking back, it's important to recall what we're talking about. We're talking about data protection and privacy. And lately, we've been focusing a lot on the technicalities of data protection. It's a compliance issue, very much. It's looked at as a compliance issue. Obviously, you can make a lot of money in data protection and privacy nowadays, but deep down, it's more than that. It's about the protection of individuals. It's the protection of a fundamental right. And the term data protection is actually a contraction of a longer phrase, which is the protection of individuals with regard to the processing of their personal data. So it's really about individuals. And in the current context where we're talking about privacy and COVID-19, you see that. It's not so much a compliance issue, what to do about the protection of persons that are affected in their private life. It's a really key issue. And today, the Data Protection Act of the Philippines is under review. So how did this review actually help find the right balance between the rights and interests of individuals, the obligations of your organizations and yourself as potentially future DPOs or current DPOs, and the authorities, governments at large? How do we handle this complexity in the 21st century? And another point we mentioned spontaneously with JJ is consent. How does consent fit in all that? We keep talking about consent. Isn't it a convenient fiction, actually, at a time when we're thinking about, giving the individuals more, more autonomy on their data? We can discuss that later, obviously. I think I can, yeah. I mean, since Commissioner Liboro is with us today, he will be in an ideal position to discuss, the trajectories of the Philippines legislation in the coming years. I thought it's important to look at the challenges that we meet, and I'm counting myself as one of yours, Asian privacy pros, because I've been living in Asia and in Asian data privacy laws for the past 5 years now. What are the challenges that we're facing today in ASEAN as we're shaping privacy and data protection in Asia for the 21st century? And actually, I think one of the biggest questions we have is how do we work in the context of a global privacy scene that has been, as I wrote, largely shaped in other regions. In other words, EU, US, basically, it's very basic, not nuanced expression, but they've been leading the show, right, on data protection and privacy. All the data transfer regulations, for instance, have been shaped across the Atlantic in the context of transatlantic disputes. And today, we're expecting the European Court of Justice decision in the Schrems 2 case, and Brussels just woke up this morning in complete frenzy because depending on what happens, well, it will reshape again the relations between EU and US on data transfers, and it will have many ripple effects elsewhere, including in Asia. So that's a challenge. So how do we keep an ASEAN narrative in data protection and data flows today? How do we appropriate all these discussions elsewhere and digest them and turn them into something meaningful for the region? And one of the point which I wanted to make is a bit of a provocation, that privacy law is a top priority that still often comes last. It's one of the problems in ASEAN. We've been waiting for legislations in a number of countries like Indonesia, like Vietnam, and so on and so forth. And they're just not coming out. We've been waiting for legislation in India, beyond ASEAN, is still not coming out. We've been looking at data protection laws waiting for a data protection bill in China. It's still not out there. So we have to adjust all the time, and it's really difficult as the landscape is moving all the time, and so many parameters come into play. So for the ASEAN privacy community, and in our different capacities, we're all part of it. The challenge is to do it all at once. We have to absorb the complexities of these frameworks that have been developed largely elsewhere, but also the pace of technology, the growing privacy expectations of individuals that are hard to translate in practice. Everything is happening very fast. The complexities of data protection policies are immense. So, others have had more time to absorb this complexity, and in particular in Europe, data protection has transformed over decades. And here in ASEAN, everything has to be done within a few years, concentrated. It's really hard. It's a challenge. How do you get things right when you don't have a lot of time and under a lot of pressure? I think Philippines actually handles it quite well. We can talk about that later. So another challenge, obviously, in the region is the diversity of Asia. Europe is a bloc. The US, the Americas have their own relations. They're fairly consistent. There are challenges, but in Asia, the complexity, we're talking about Asia at large, but as you know much better than I do, it's the diversity in Asia is a challenge. It's hard. Data protection, privacy are not looked at the same way. Data flows are not regulated from the same perspective. Sometimes it's a human rights issue. Sometimes it's more a trade issue. Sometimes it's a digital sovereignty issue. We're talking about data localization. We can discuss how I don't think GDPR and data transfer restrictions in traditional data protection laws are not data localization laws. That's a very interesting discussion we can have. So it's a challenge, but the work we do at ABLI also shows that there are lots of reasons for hope and professional growth for DPOs that have never been so necessary in organizations. They have a key role to play, and COVID-19 does not challenge that. On the contrary, it actually enhances the role of data protection officers and privacy professionals today. We've never needed such guys more as when data has become so important, and we're talking about sensitive data here. How do we adjust to this reality? You need the guys internally who can, work out all this complexity. That's the role of the DPO, of the Privacy Council. It's a key role to have. And I think that role is developing in Asia, and it's one of the big reasons for hope. The other one is regulatory networks of cooperation actually are stepping up, and Commissioner Liboro can discuss that later. ASEAN is doing a lot of things to promote privacy and responsible data flows. So there are lots of positive developments in Asia at the moment, and it's professional growth at hand for those who invest time and energy in the privacy field. So today we're actually in a phase where GDPR has been fairly digested as much as it can be. We're now looking ahead. We're looking beyond. What's the right regulatory system for tomorrow? As GDPR might, we're discussing how its successes, but also the difficulties in implementation. There are very important developments happening elsewhere. In America, obviously, with the CCPA and all the discussion on the privacy, federal privacy laws, all this has an impact in Asia, and we have to look at that and absorb what is necessary in an Asian context and adjust and see what works and what does not work here. So what's the right regulatory system for tomorrow in this region? We can discuss that later. But I think one of the key components we have to discuss is the role of the data protection regulator. Since Commissioner Liboro is with us today, it's a very hard job to be a data protection officer. It's also a very hard job to be a data protection regulator. And somehow there are lots of challenges that we share that we should discuss together. So next. I'm controlling JJ's screen, but it's not really working.
I'm fighting you.
You're fighting me.
Wait,
not a good situation to be in.
Right.
Can you get to my last slide?
Okay, hold on.
You can. Yeah.
Is that the one?
Thank you. That's it.
Right.
Oh, that will be quick actually. It's where's Philippines today on the global privacy map? Again, we'll discuss that later. But I believe personally, and it's not mere flattery because the commissioner is live with us today. But I think Philippines has a very special role to play in ASEAN and beyond that in Asia and beyond that in the global privacy community. Well, first of all, Philippines is strong. Okay, COVID-19 is impacting all of us, and it's really difficult today. But Philippines' digital economy remains strong, and will go back to normal, I hope, very quickly. Actually, we've never relied on data flows so much since COVID-19 broke out, and data flows, means a lot to Philippines' digital economy with the BPO, strong BPO industry. But beyond that, the Data Protection Act has very unique features compared with other ASEAN data protection laws. First of all, it's a legislation that's truly inspired by the protection of the individuals. It's truly that's you, JJ. It's a human-centric legislation. It's also obviously aiming at accompanying the growth of the digital economy and supporting you know, consumer protection in this area. Oh, no, my God, no, that's
Sorry.
not the right one. We can show
Sorry.
that. That's a very green slide. We can show that later, just in case. This balance is actually inherent to the Data Protection Act of 2012. And it's also a comprehensive legislation, comprehensive law in the sense that it covers the private and the public sector, and that has lots of consequences for the regulator. There's an expertise in Philippines that is very significant, which is quite unique in Asia because the law has been here for quite a long time. The regulator has been here for less time than the law, but it's still been around for a long time. So there's a lot of expertise to share. And I believe the NPC in particular has become very visible on the international scene. So that's something we can capitalize on later. Well, I'll stop here, and then we can that's the general you know, presentation. In other words, just let's take a step back and see how on our in our day-to-day job we can actually make sense of what we do as privacy professionals. Let's go beyond compliance and think about why we're doing this, the context in which we're doing this, and how we can all work together to well, deal with all these challenges. Thanks.
All right, thank you, Clarice. So our next
Stop my
speaker,
video. Yeah.
yes, our next speaker is the National Privacy Commissioner, Raymond Liboro. He's the inaugural commissioner for national privacy. Is a graduate of the University of the Philippines in economics. Was formerly the assistant secretary of the Department of Science and Technology, and I believe he takes that expertise in his experience as assistant secretary of the DOST, as he does his work now as the chair and commissioner of privacy in the Philippines. He's also and one of the I think the most significant achievements of this privacy commission is the fact that the Philippines now is actually in the world map when it comes to data privacy. So he is an executive committee member and is the head of the COVID-19 task force of the Global Privacy Assembly. He has also secured the Philippines a seat in the biggest data privacy organizations in the world, the International Conference of Data Protection and Privacy Commissioners, the ICDPPC, and the Asia Pacific Privacy Authorities Forum, APA. And in fact, in 2019, the National Privacy Commission hosted the APA annual conference in Cebu, which is an international forum attended by many, by actually international attendees, and the NPC hosted it. So I'm very pleased to introduce and have now, sorry, Chairman Liboro. I'm trying to stop sharing. All right, thank you. Welcome, sir. Sorry, I think you're on mute. Hold on, let me unmute you. Sorry.
Unmute, all right.
Unmute, there you go.
Good afternoon, JJ. Good afternoon to all the participants. Good afternoon to our friend Clarice. You mentioned the Asia Pacific Privacy Authorities Forum held in Cebu. Clarice was there. She shared her expertise with all of us. Clarice is a ringside viewer of what's going on well, generally about privacy, but she's sitting in the ringside watching developments in the ASEAN. A pleasant good afternoon to everyone, and I hope everybody is in good health amidst this pandemic. Just yesterday, of course, our president announced that we will continue to be in GCQ. I'm talking about Metro Manila. I just had a glimpse of our participants. JJ, I'm happy to see that many are coming, calling in from the other regions. I saw someone from Masbate, from Batangas, well, really, the attendance today speaks, of course, highly of your ability to attract our data protection officers also as a practitioner, as a respected professional. But I really am hopeful, of course, that the DPOs are here as privacy champions. But I also understand the situation that we are all in, and also that of the DPOs during this time. I cannot divorce my talk from COVID-19, and really, I will take this opportunity, if you don't mind, all the participants here, to really report out on what's happening. Let me make this a very candid exchange with all the participants this afternoon of developments in the NPC, what we have observed so far. And this is much needed before we can really jump towards really projecting the trajectory of where this is all headed. So I have JJ, you owe me one. I burned the midnight oil just to prepare for this. But you know, while I was writing it and you know, talking about data privacy trajectories, humaba na eh. And I sabi ko, let me just do this as sort of a report, not to everyone. I did not prepare any slides, unfortunately. So I just hope that everyone listens intently to this. COVID-19 is constantly altering all facets of human society, from our mundane activities such as shopping and dining, up to more complex and collaborative functions such as business operations and governance. We are seeing all these changes not only in the Philippines, but also in jurisdictions and governments and states across the globe. Various government and civic interventions to prevent the spread of the disease are intensifying the use of personal data. Consequently, data security and protection, or the lack thereof, determine the effects of data collection, use, and processing, and its impacts to the concerned data subjects. In the earliest stages of the pandemic, we have seen the effects of the misuse, and we're working on to prevent the misuse of personal data. Yung pong maling gamit at yung hindi nagamit, the misuse. Unauthorized disclosure of sensitive personal information of COVID-19 patients, which resulted in social vigilantism, discrimination, and stigmatization, physical assaults against our frontliners, and many more incidents of data privacy violations, create risks more harmful than the virus itself. On the other hand, we're also concerned about the misuse of data to fight this pandemic. That is why we have tried our best to provide guidance on the proper use and sharing of data. We have involved ourselves in directly contributing to government measures, such as the crafting of contact tracing policies with the DOH, reviewing data sharing agreements with concerned agencies to effect the distribution of SAP, social amelioration packages, and other relief packages to the needy and the marginalized. You're talking about the DOF, the DSWD, the DOLE, and the NEDA. We have no playbook which provides the perfect strategies against a pandemic of this scale. However, we at the National Privacy Commission are always tuned in for rising issues and challenges faced by both public and private institutions in their fight against the disease. We are issuing bulletins to address emerging privacy concerns and to guide everyone on the best practices of data protection, especially where the use, collection, and processing of data is involved. As the virus continues its lock on the nation, it is important to realize that COVID-19 is imposing both immediate and long-term impacts to governments, businesses, regulations, and human interactions. This is highlighted by a growing digitization of a wide range of human activities, which are most likely going to be of a permanent nature. This trend will continue as we discover new beneficial uses of data, even after the COVID-19 pandemic. Unfortunately, most of us are not prepared for this sudden tectonic shift. If we examine closely, most of our existing regulations and business practices rely heavily on close and personal contacts within a physical workplace. Hence, there is a need to revisit and update our traditional practices, data protection tools, and analysis of legal requirements to keep up with the times and to reduce risks associated with digitization. Organizational accountability will play a key role in ensuring a data-resilient environment. Unlike the natural risks created by COVID-19, privacy risks are man-made. They can be prevented and mitigated, especially when we utilize the principles of accountability as a tool to support high standards of data protection. To project the trajectory of data privacy, one has to really project, before we can project the course of the future, we need to turn to the lessons of the past. And our data in the NPC show that even before this abrupt digital transformation forced by the COVID-19 pandemic, our people have already started shifting to the digital way of doing things. In 2019, we saw the sudden rise in popularity of obtaining microloans, online lending, not from the traditional channels, but from the comfort and convenience of the smartphones. By simply downloading an app, people had ready access to instant credit without collateral, or so we thought. From just over 200 complaints received by the NPC in 2019, it blew up by increasing 900%, or a staggering 1,800 plus complaints in 2019. More than 80% of these complaints were related to online lending applications. The common privacy complaint was that when they defaulted in their loans, these online lending companies would contact people in their phone contact lists and shame them into paying their outstanding loans. No collateral loans? Not quite. Apparently, the personal information and the reputation were the collateral. At the start of 2020, the COVID-19 pandemic forced us to quickly adopt new technologies to solve our new normal problems. And some were too eager to embrace data-hungry technologies without giving privacy by design much thought. Unsurprisingly, we receive an increasing number of personal data breach notifications, some of which are from the academic sector. I'll be discussing that later. As we investigate these unfortunate incidents, we advise our schools and universities to beef up the privacy and data protection stance during this time. For just the first half of the year, the National Privacy Commission received a total of 120 data breach notifications. This already represents 75% of the total number we received back in 2019. As businesses and government offices turn to digital technologies to sustain operations amidst the pandemic, we are also starting to see a slight shift in the causes of breaches reported to us. In 2019, most breaches were caused by human error. 45% of those breaches that were reported to us were caused by human error. This year, malicious attacks now account for 44% of the breaches reported, followed closely by human error at 43%. The top specific causes were hacking, potential unauthorized disclosures, and simple email errors. Many of the systems that were hacked had SQL injection vulnerabilities. In terms of sector, health facilities suffered the most number of data breaches, 22%, since the pandemic entailed intensified personal data processing in the sector. It was followed by the education sector at 18%, as schools shifted to online platforms to enable various modes of learning while COVID-19 response is ongoing. The government and BPO sectors each accounted for 10% of the breaches. The non-bank financial institutions, 8%, and the banking and telecommunications sectors, 5% each. Based on these observations, we developed pertinent standards and engaged the sectors concerned. In response to the increasing number of breaches involving potential unauthorized disclosure of sensitive personal information of suspect, probable, and confirmed COVID-19 patients, we issued NPC Public Health Emergency Bulletin number 10 on how to protect patient data. Currently, we already have issued 15 bulletins during this pandemic. We advise PICs and PIPs in the health sector to first and foremost remind officials and employees of their ethical and legal duty to protect patient data, and to ensure that non-disclosure agreements and related contracts are in place and enforced. The sector was also reminded to establish access control for patient data based on list privileges, allowing health personnel only the minimum and necessary access to enable the performance of their functions. The importance of physical security measures in protecting patient data was also highlighted, since a number of the breaches resulted from weaknesses in this area. These measures include equipping facilities with physical access controls, disclosing patient data only to proper authorities and only in appropriate areas, protecting the device display from unauthorized or accidental viewing, and locking storage media away when not in use. We also emphasize the need to implement technical security measures when storing and transmitting patient data, encrypting data both in transit and at rest, and using a secure communication platform for care team collaboration and patient communication. Members of the education sector were gathered last June 26, as we noticed a surge of malicious attacks in schools during the second half of that month. We presented what the profiles of the breaches were, the vulnerabilities exploited, the weaknesses in the breach management we observed, and the recommendations to address these weaknesses. We highlighted the need for schools to invest in the privacy and security of their systems. This includes capacitating their teams. Unless they do, they will not be able to detect security incidents in a timely manner. Instead, they would continue to heavily rely on media and social media reports, which of course would mean that the damage is not only done, but also out in the public. Outsourced or done in-house, their system developers should adopt best application coding practices. Security audits and tests like the PIA, alam niyo lahat yan, and the VAPT, Vulnerability Assessment and Penetration Testing, should likewise be conducted. Most importantly, they should have clear security incident management policy and procedures to ensure timely and effective breach response. A few years back, we introduced the 5 pillars of accountability, compliance, and the practice of ethics. I just would like to go back to the slide of Clarice earlier, where she said it's really going back to the basics. And to the DPOs present today, it's really going back to the basics. Refresh yourselves. These 5 pillars, we set those in motion a few years back for periods like this. We were built for crises like this. In the private sector, business organizations are expected to reform their workforce practices to include the possibility of lockdowns or even work stoppages. Work from home and other alternative work arrangements will become the new norm to allow continued operations while ensuring the health and safety of their personnel. However, this setup is not without risks. Unauthorized access to and improper disposal of documents containing personal data due to unprotected home devices and physical files are just some of the potential dangers that come with it. In this context, data privacy accountability should be understood and implemented not only at an organization level, but also at the personal level of every employee. Majority of businesses are expected to refocus their strategies and resources to digital work, teleconferencing, and use of online solutions in lieu of traditional business protocols or processes. Hence, it is important to capacitate and familiarize members of the organizations, from top management to the rank and file workers, on the importance and implications of data protection and security. Data privacy as a concept should evolve within organizations as they adjust in the post-COVID-19 world. I'm already looking to a post-COVID-19 world. Hence, we will see the bigger role of data protection officers in corporate strategy and management, product development, human resources, finance, marketing, and almost all aspects of a business. You know, I had to mention a few weeks ago, I bumped into not literally bumped into somebody, a DPO, who told me that she was afraid that probably the DPOs will be the first to fall when retrenchment comes. And I told her that, on the contrary, I don't think that will happen because, again, as everyone shifts to a digital environment, the role of DPOs will ever be more important. And that's also the reason why I kept on issuing guidance and resources, materials to all of you, is to give you that confidence to tell your bosses on what to do during this time. In this regard, we foresee changes in the roles of the private sector in matters of public concerns, which are traditionally within the sole responsibility of the government. New private-public partnerships and joint activities may emerge and may include new ways on data sharing between private institutions and government agencies. I'm foreseeing this as a trajectory because, as you have seen here in our country, we talk about contact tracing, the first to respond was really the private sector. As a regulator, we are expected to implement and interpret the Data Privacy Act of 2012 and other pertinent legislation with a degree of flexibility that will allow new forms of collaboration between the government and the private sector while ensuring trust and compliance with legal requirements. I will now go to our regulatory role. Data privacy regulators across the globe, including the NPC, need to examine their participation and roles consistently, even after the COVID-19 pandemic, to remain relevant and in touch with technological advancements, business trends, and public sentiments. The same is true not only in the local occurrences, but also to the international media. Collaborative actions such as the Global Privacy Task Force on COVID-19, which is headed by the Philippines, will be a main measure during and post-COVID-19. Overall, our experiences are invaluable lessons to others, especially in other jurisdictions which are still undergoing similar experiences. These collective insights and experiences from data privacy authorities will pave the way for globally harmonized and consistent data protection rules on national, regional, and global levels. In the local setting, you can expect the National Privacy Commission to continue engaging our stakeholders constructively and implement responsive regulation as a main strategy for enforcement and, well, for enforcing the law. We will continue to maintain and enable trust of the citizenry in both the public and private sector so that people, in turn, will allow the use and sharing of their personal data for legitimate objectives. Accountability of data controllers and processors are needed to foster this culture of trust. Hence, as we move forward, the NPC will have to conduct close coordination with all of you, with all controllers and processors, in defining clear accountability frameworks, especially for responsible data use and the sharing between and among private and public organizations. We recognize the positive impacts of technological advancements in response against emerging situations and public health risks like COVID-19. Hence, there is a need to balance regulation to prevent curtailing innovation while ensuring the privacy that data subjects expect. To do so, the NPC, the National Privacy Commission, your National Privacy Commission, will facilitate beneficial uses of data by proactively demanding, explaining, and encouraging organizational accountability controls at all stages of data collection, use, and the entire processing. We in the National Privacy Commission are not immune to the challenges of this pandemic. Public service must continue, even if it necessitates working mostly on a work from home arrangement, conducting meetings through video conferencing platforms, sending emails instead of paper memos, digitally signing reports, orders, and resolutions. And soon, by the way, we will be conducting virtual hearing of cases. We are also active in the ongoing debates on the proposal now in Congress to revisit the now 8-year-old Data Privacy Act of 2012 to adapt to the fast-evolving privacy landscape. Finally, we should always remember to look at both sides of the coin. Just as technological tools have their benefits, they still present risks over time and are prone to attacks, hacking, abuses, and other nefarious purposes. To this end, the National Privacy Commission will establish a framework for ongoing review and oversight to ensure that these tools are only used for legitimate purposes. But our data remains secure and consistently updated with the most relevant security features. So with that, I'd like to thank everyone. Thank you, JJ. And I'm happy that there are so many DPOs here present. And I hope you understand, where the NPCs are really coming from. And I hope we have been of help to you during this time. Thank you very much.
Thank you, sir. So I think we can open to questions. Let me just change my view here. Okay, so we have a question. Actually, we have a lot of participants coming from different places. There's one of the most interesting is actually we have participants coming from as far as Iloilo. So somebody's coming in from Iloilo. Just for the benefit of everyone here. So we're now, all three of us are now seen on the screen by our attendees. So Clarice actually, although her background shows the Supreme Court of Singapore, is actually coming in from France. And I think a question was asked earlier by the chairman about what is the situation like in France right now with respect to COVID, and what are the privacy concerns that you're dealing with?
Thanks, JJ, for the question, and thanks to Commissioner Liboro for really good presentation of the challenges that DPAs, data protection authorities meet with, in the current crisis. Well, France is not immune to that. Obviously, I'm talking to you as, someone working at the Asian Business Law Institute, but on a personal level, I'm happy to share, more about the French situation or European situation at large. Well, it's okay. It's not great, but it's okay. I think everybody's getting used to the idea that this is going to be with us a long time, and that we have to get used to a new normal. So there are still people being contaminated. The health system is taking the shock, but the economy will be very significantly impacted, has been, but we're expecting maybe a second wave of contamination, but before that, the wave, the economic wave, and that's very serious concern here and across Europe. That said, there are challenges we share that are shared globally, and which Commissioner Liboro mentioned. Raymond, you were explaining the challenges for DPA, of providing answers to everyone, whether public stakeholders that are taking measures to fight COVID-19, also addressing all the very operational questions from companies, employers, employees. Data breach notifications, of course, are basically reveal which organizations are targeted. It's a very useful tool, actually, for a regulator to have, being notified of data breaches. And I'm quite sure that CNIL, which is the local regulator here in France, faces exactly the same challenges, scams, and so on and so forth. So what to say? I think strangely, Europe has to learn from Asia in these circumstances. When I was still based in Singapore a month ago, and even earlier this year, I realized, that the SARS situation a few years back has actually had a huge impact on how ASEAN countries, and Singapore in particular, actually shaped their public response to the virus. And honestly, as a European looking at these, as a French citizen looking at French developments from afar, I was actually, worried that this disease was not taken seriously enough, and that the measures that had been sort of fireproof, in 2008 and before had actually not been implemented in France and generally. And we see that the West at large has had difficulties getting used to this pandemic and how to deal with it. Now, the privacy implications, since we're focusing on that, I think are huge, and they're going to be with us again for a long time, and they might evolve. I don't know if you want me to comment a bit more on the regulatory response to these challenges. Maybe we can discuss that later, but I think we have to be ready to accept, and the regulators in Europe have been ready to accept that in periods of crisis like this, and this is undeniably the crisis, the biggest crisis that data protection authorities have been facing in the past years. Well, sometimes data protection and privacy have to, not to take precedence and go, not be the top priority. Health is a top priority. Maintaining the health system in a country is a priority. Keeping businesses afloat is a priority. Now, the role of the data protection authority here and everywhere else is to contribute to the how. And there are lots of measures to be taken to mitigate the privacy risks of measures that will be intrusive by essence. And there are options, for instance, in contact tracing, there are options on the table, and that can mitigate these privacy risks. How do governments react to that? That's really a very interesting discussion to have. When there are options on the table, you need someone to guide you as a government, to make the right choices. And this is the role of the Data Protection Authority. We can discuss that more in depth if you want.
Actually, that's very interesting. There's a question here about, and a lot of questions actually relating to contact tracing. In particular, with two things that we've seen recently. One is there is a contact tracing app that the government endorsed. That's first, and of course there was some collection of information there. The second is a common practice that's going on out there. I haven't left the house too often, but apparently when you enter a restaurant or a public place, you have to fill out a form, and then it asks you a lot of personal information. Supposedly this will be used by the establishment. And what are your thoughts on that, Chairman? Do you think these are effective measures? Or
All right, let me tackle the 2 points that you raised. First is on the contact tracing. Again, as a providing guidance to the overall effort, I think we came up with a bulletin. I think it's bulletin number 8 on digital solutions in response to the pandemic. And I remember what we said in that bulletin. We are for the successful use of digital solutions during this pandemic. But for it to be successful, it must have 2 things. It must possess 2 things. It must be trusted, and it must be inclusive. In nowhere in my bulletin did I mention that you have to be compliant with the NPC requirements. That's the only 2 things that I really advise. It must be trusted and it must be inclusive. Meaning for it to work, it must have the general acceptance, and everybody should be downloading it for it to be effective. People will not download it if they will not trust the app. No, so with regard to that, I guess going to what you mentioned earlier, the government did endorse an app. It was, when this pandemic started, the rush to come up with and introduce apps, there was absolutely, born out of, again, uh, the desire of everyone. And as Clarissa's observed, of course, the digital community here is quite large, and everybody really wanted to contribute. And well, there are companies, and including one that that was actually endorsed by the IETF included. But there are many apps, and there are some of them are regional apps. Some of them have been introduced in the provinces. So really, there's practically no way to to assess and catch up with all these applications. So when we came up with that bulletin and reminding everyone, also the IATF took note of that. And they also acted on the issues surrounding these the originally endorsed applications. That's why in the latter part, subsequently resolutions were introduced to make sure that the controllership of the data is made clear through through binding deeds of donation, because this was introduced by a private company, and it was established that DOH must establish full controllership over this, and so the government's response also again they responded to it by coming up with ways to put things in order. So right now we are sitting with the Department of Health. We're also looking at the other applications, apps in the DOH. So we belong to the, there's a subgroup on digital solutions and ICT. And our team from our compliance and monitoring, from the Data Security and Compliance Office, is meeting regularly with the DOH on this. Bukod po kasi doon sa Stay Safe, marami pang apps eh. COVID kaya, marami pa po yan. So lahat po yan ngayon ay again nire-review, tinitingnan, and kasama po ang National Privacy Commission. The last thing I know is that yung pong we will soon be introducing itong exposure notification app produced by Apple and Google. All right, and the API has been awarded already, and soon the government will also be launching this. Now, with regard to the question, JJ, about again the collection happening in establishments. Of course, this was born out of a memorandum or circular order coming from the DTI. All right, so what we did was actually write DTI Secretary Mon Lopez a few weeks back, and he responded positively by calling on within the IATF to revisit this, and it was now discussed in the technical working group of the IATF. The technical working group actually vets the program that are being introduced to the IATF body. And this was discussed again, and the points that we raised, again, the proportionality of the data, how are we going to secure that, or how do they intend to secure this data? So lahat po yun, nire-revisit din ngayon. So I guess soon we can expect, again, more detailed guidelines on this one. So my point here is this, right? Ang key ho natin dito sa laban natin ngayon, yung responsiveness ng bawat isa sa atin. This is a very unfamiliar situation that we are all in. And everybody wants to contribute. Of course, mayroong iba gusto gamitin ito for scams. That's an altogether different audience. Ibang grupo yun. Pero tayo gusto natin makatulong dito. So tayo rin, yung government din, ang hirap din po maging mamahala, maging gobyerno sa panahong ito. So, very important po ngayon na very responsive yung ating yung lahat tayo, controllers, processors, government agencies. Alam niyo, lumabas po before yung tungkol ho dun sa Coast Guard na nilagay nila yung mga pangalan sa Facebook para makauwi yung mga OFWs, yung mga ganun. Mas nag-raise din ho ng concern yan. Pero ganun din po, no? Once na napaliwanagan din po sila at nag-respond din naman yung Coast Guard, tinake down na rin ho nila yun. So in this pandemic, wag ho tayo din kaagad maghusga, right? Relax lang tayo, okay? Government is really trying its best to respond to the situation. And as I mentioned, it really intensified the use of personal data. So far, again, we're not tiring in issuing guidance and bulletins to everyone. We have assisted so many government agencies in their data sharing agreements, emphasizing again how the need for transparency. I was calling really for, I think transparency is key in all this. Siguro again, just to guide everyone, no? All of you will be deciding at some point as DPOs, as companies, as you digitize, no? Ano ba, DPOs, you're built for this. I just have to remind all of you, lahat ng nile-lecture namin ni JJ, lahat ng all that lectures that we've done, these 5 pillars, they will never go out of style. And believe me, we built the Data Privacy Council. We have sectoral feedback, sectoral representation. Now we have formed a task group composed of universities and colleges, and we're building, we're developing a code of practice for online learning during this time now with the participation of controllers, no? Of universities and colleges. We have also put on regulatory sandbox this telemedicine project of the DOH. This is the first regulatory sandbox project that we launched as a DPA. And we have identified again the challenges posed by doctors meeting their patients physically, so the need for telemedicine. We had to again tap into the reservoir of private initiative, those who have created platforms prior. So that's why also I mentioned in my talk, we would have to explore now new public and private partnerships and look at how data can flow between them. Between the government and between with private companies, just like what's happening now in the telemedicine project and program. So ganun po, no? Kasi ready yung private sector dun eh. Hindi pa ready yung government. No? So we had to tap them. And so we sandbox it, and then we are monitoring it. We are playing oversight also sa ganun. Ganun din po sa contact tracing. Ganun din po sa maaring marami pa pong ibang bagay. So again, we will have to rely on accountability. It's the gist of my talk. We have to rely that everyone here, lahat po kayo dyan, 323 companies ang nandito ngayon, di ba? Your duty of care. Yung inyong do no harm, bago natin gawin, do no harm, the duty of care. So I always rely on that, no? Many times, a few weeks ago I was interviewed, sinasabi nung broadcaster na bakit ganito, bakit pinapayagan yan, no? But I was telling them what is expected from you, and Clarice nicely pointed it out. The dual role of DPAs of our law. It's not only to protect the rights, the data privacy rights of citizens, but to ensure there's free flow of information. That's the balancing act that we're doing. So we cannot, you call that what? Preempt and, bago nyo gawin, dadaan sa amin. No, we expect you DPOs to decide and say, this is a goal. Because according to the principles of privacy, according to what we've learned, according to the law, this is what is supposed to happen. Right? So ganun, that is the bigger role now of the DPOs, as also Clarice supported earlier. DPOs, you have a huge role in your company survival during this time. You will never go out of style during this period.
Thank you for that, sir. So actually, I'm going to latch on to something you said earlier, which I thought was very interesting, where you mentioned about engendering trust, right? Building trust with it as a DPO, and I think that's an important role that it's not very explicit in the law. The law is very mechanical in the sense that you have to get consent, but it's interesting that the regulation or the advice given by the NTC does not say do this 1, 2, 3, 4, but instead build trust, which I think is perhaps the forgotten objective sometimes in when data privacy is under discussion. Have you seen that in Europe, Clarice? Is trust, building trust, has it paid off for companies that have engaged in that kind of compliance?
Okay, I haven't been here long enough to do that assessment in full. Allow me a general comment first. We're in the midst of a crisis. I think we're all trying to do something useful at our respective levels. In that context, I think we've been in sort of startup mode for a lot of us. If I take the example of contact tracing apps, it more or less started in Singapore, right? That with the Trace Together app,
Yes.
GovTech actually developed this app, not necessarily to put it, I think, at the heart of the public policies, to fight COVID-19 in Singapore, but really out of a willingness to help. What can we do as government tech agency to help? And because contact tracing, physical contact tracing was considered so useful in Singapore's response to the virus, obviously tech people were looking at how they could help. And so they devised this very much in startup mode, but it was with the privacy by design principle at heart, since going for the Bluetooth option rather than geolocation. Hence, a number of measures that you can look up. I'm not going to detail that, but what struck me was first the willingness to help. Let's do it as fast as we can, as well as we can in the circumstances we're in. Now the phenomenon, let's say, of contact tracing apps has gone around the world, right? Has taken the world, and every single country has now set up more or less a contact tracing app with different options. Again, there are options, and I think it's important to look at all of them to decide what is right. First thing, it's great to have a principles-based law with a clear purpose, because then you have a compass, you know what to hang on to. There's the principle, okay, there's consent and all that, but there's also the necessity principle. Do I need that data? There's the purpose principle. Why am I doing all this first? And then I can assess the necessity principle, by the way. Transparency, I think, is key. And then in a very, individual rights will be key. Access, erasure, that's in the law, right? That's coming up in the bill in Parliament. How do I empower my people so that they have trust? And indeed, the trust issue is key. And again, having a human-centric legislation is very important. There will be a time, and that's my second point, for assessment. And that's, we're in the midst of a crisis. All of us, we're doing what we can. We're launching ideas, initiatives. One day, someone will have to do the job of saying, okay, that's working, that's not working. Contact tracing apps, are they truly useful? One day, we'll have to make that assessment. Statistics will come out. Do we really need this? And all the data that has been collected, with or without consent, by the way, because the app can be made compulsory when it remains optional elsewhere, will it be destroyed? What kind of transparency, will government provide on what happens to all that data? I think this is where, obviously, the regulators will have a key role to play, but it's also for governments to play that role spontaneously. Now, don't leave it all the time to the DPA and put it in an impossible position sometimes. It's also up for government to take their own responsibilities and say, we've collected all that data because we had to do something at some point. But this is what we're going to do next. I think the regulatory sandbox is, telemedicine is actually a very interesting case study also. Same thing, sandbox, we're trying something, and one day we will assess whether it works or not. What are the risks attached? Well, that should be assessed beforehand. But the consequences, of collecting that data in that context, is it working? And shall we consolidate that experience and get it out of the sandbox and make it something permanent? I think we're in the midst of, of this situation where we don't really know what's working or not. But just a personal comment also on the French side. Definitely, to me, coming from Europe with a strong reluctance to, public fining, if you will, because this is where the data protection laws come from in Europe. You know, it's putting checks on the government, on the data it controls over citizens. Frankly, letting ID, you know, ID numbers, names, you know, even, you know, taking your temperature to enter public spaces, maybe not public buildings, but, you know, average shops, like going into a restaurant. I mean, to me, honestly, it's weird. If not to say, maybe not shocking. And I wouldn't make a legal assessment like it's illegal, but I mean, to me, honestly, that's a bit over the top. But again, I mean, these guys are restaurants. They're trying to do the right thing. They want to protect their customers. They want to protect their employees. Maybe they're not doing it the right way, but let's give the benefit of doubt, you know, to organizations that are struggling. But again, think about the necessity principle. Why am I doing all this? Is this truly necessary? I think that's a key, you know, it's a compass, really.
So it's interesting you said that, because I think a lot of DPOs are focused on compliance. Their first stop always is let's get consent, let's get consent. And in fact, Chairman Liboro mentioned about online lenders, micro lenders that were very popular last year. And what happened was they would get they would ask to access all of the mobile contacts of the borrower. And if the borrower doesn't pay, they send messages to all of their contacts saying, you know, Mr. So-and-so hasn't paid this debt in this much, as a form of collection and shaming. And I was thinking in the back of my head, it's possible that the app got the consent. In other words, if you look at the privacy form, it's there. It says we can do this and we will do this in case you don't pay. And I think that's sort of you have the mechanical compliance, but somehow I think you've lost track of the principle, right? And who are we supposed to protect anyway? I think when it comes to data privacy. Yes, Chairman. You're on mute. Let me unmute you.
Right. Thank you, Jane. Now that you mentioned that, I wrote something, I think a few weeks back, about what they call now the privacy paradox. And this is actually initiated by Professor Daniel Solovo. I think he's from George Washington University, a privacy professor. Well, he wrote about that. And the privacy paradox, it's basically what you mentioned. People would say that they value privacy, and yet they would exchange that for an umbrella, right? You know, if a blank credit card registration form is shown in front of their faces, they would readily give it because their personal information in exchange for an umbrella. Not that they don't value privacy, but so it really opens up now well, again, this concept, or call it now the paradox itself. That's why really the onus of protecting individuals' data or personal data at this point, I would really give it to the controllers and processors, who must build that architecture to make sure that the information used, share, and disclose, they do that with privacy in mind. And really, the clarion call is both for accountability and responsiveness during this time. I would really put responsiveness here during the pandemic, because again, because of the rush to look for so many solutions, an app, it could be an app, or a form of collection to aid in the response of COVID. Yes, sometimes we don't do it correctly in the first during the first get-go, but DPAs must be able to point that out. And really, what should happen next is we're hoping and praying, of course, that everyone would respond to our call. So far, I would say, again, with the many initiatives that government is taking, they have given the NPC a seat at the table in a way. They've been calling us on matters that involve widespread collection of data, some involving really the fine details or policies that would have an impact. Again, even government agencies who are in the rush to provide relief uh, services, financial packages, would still knock at our doors and really ask our help in crafting data sharing agreements. And that, again, this is the part of the role of DPAs during this time. And I think what we have popularized as a DPA, as an NPC, is the posture, our posture of both being an enabler and a protector during this time. We have embraced that. And we thought that as a DPA, a responsive regulator, we should be both an enabler and a protector. And, we're still, of course, mastering those two roles. But this has actually clarified, not only for me, but for my staff, on our role during this pandemic. Right? So we struck this project, regulatory sandbox project with the DOH. We came up with joint issuances of contact tracing procedures with the Department of Health. We have and pretty much, well, we are being consulted on certain aspects of, we have enabled or agencies also to revisit policies that have been previously issued. So yun po, no? So wag po tayo kaagad, tayo magpapanik kaagad. We just hope na lahat po tayo, we're on the same page on this, and everyone is really trying to beat COVID-19 and save the country.
Right. I think perhaps a good message to tell our viewers, people attending today, that at least my understanding, and I think I'm getting the sense from the both of you, is that data privacy law or regulation, as we see it now, is only its form today. It will change in the future. In fact, the NPC is already proposing changes to the Data Privacy Act. And the sense that I'm getting, I think, where as follow on from the from privacy paradox that you mentioned, where I think the people who are supposed to be protected, the data subjects, need to take control. And maybe they don't have the ability to do that because it's hard enough to balance your checkbook, to manage your life, that you have to manage every piece of data that you leave everywhere. I'm thinking a market solution would be to create some sort of intermediary, an incentivized intermediary who will champion and protect. So you have we're now relying on controllers to do that. That's good. But on top of that, so the controllers now are worrying whether they have the consent to use information. But if there is an intermediary who can protect the data subjects in an incentivized way. Currently, I think a lot of the incentives go in favor of selling data and then giving no compensation to the data subjects if somehow a mechanism can be had where the data subjects themselves, right, can receive some compensation and intermediaries can make money. Then there might be a balance struck between competitive forces. Okay, very interesting discussion here. What would you say about consent, Clarice? I mean, in having spent all this time in the data privacy field. Wait, you're muted. Let me unmute you. Yes.
Oh, you unmuted me. Yeah. Okay.
Yeah. All right.
Consent. Oh my God. That's a difficult one. It's a difficult one because I think consent generally has become overrated, and we keep talking about consent, like, tick the box and you're done, you're compliant. That's risky. I think there are two situations. There are situations where consent cannot reasonably be freely given, and typically in an employment context, consent would mainly not be an appropriate legal basis. And often, actually, some data protection laws explicitly provide that in an employment context, specific rules apply to process employee data, and consent is not the right basis. There are other circumstances where you can tick a box. It won't gives you a free rein, to processing data. I was looking at the many questions that have been asked that go in all directions and reveal the complexity actually of dealing with the consequences of the pandemic in an organization, and actually lots of questions hang on. Do I really have a choice? Can I really avoid providing my information to go into a restaurant? Well, in that case, I mean, going into a restaurant, okay, fine, you might have a choice there. If you're in an employment context, and if you're in a relation with the health professional, if you're in a relation to the government to get an SPN, I think that's the Philippines acronym, right? To get help from the government in the context of a financial package, for instance, or also some form of social grant or help. Well, that's more problematic. So there are discussions all around the world as to the validity of consent. I think it's hard to give definitive answers because we're talking a bit in the abstract right now. But all around the world, there are discussions on alternatives to consent. And in particular, we're discussing this with JJ. It's a difficult concept, but the concept of legitimate interests, for instance, is actually a very interesting one to pursue, especially in a COVID-19 context where, I mean, individuals do not really have a choice. And the question is, not so much the choice, but then what are the guarantees that are put in place that actually offset the fact that an organization or the government will collect some data and sometimes, can be fairly intrusive. How do you offset the impact and the risk? And that's, again, the role of the DPA with regard to government, and the role of a DPO or a privacy professional or a legal practitioner that will, provide advice on the implementation of such and such measure. That's the difficult role. But again, I think we have to move away from the tick the box, exercise and consent as the alpha and omega of data protection. And again, that's a global movement. That said, and I'll close on this, so Commissioner Libero will certainly have lots of things to say about that, but consent remains the cornerstone of many data protection authorities, data protection laws, sorry, all around the world, and especially in Asia. And it's hard to move away from that, entirely. I think consent being put at the heart of the data protection laws is actually more a signal that the individual matters and that you can't do without the individual in the data protection equation when you're putting up, new processing operations and so on and so forth. The individual should be put at the heart of your reasoning. So whether it's through consent in another way, it's put the individual at the heart. And then obviously, from there, pull the string, and you have all the measures in place that enable an organization to achieve its own legitimate aims and perform normally. I think I'll stay here. Happy to provide more detailed answers on specific questions.
JJ, if I may, okay.
Opo.
Oh,
Yes.
there are so many DPOs now present in this webinar. And again, well, now that we're talking about consent, of course, we all know that consent is one of the local criteria, only one of the local criteria for processing under the DPA. Legitimate interest, as you mentioned, Clarice and so JJ. And now, I'm really emphasizing now the role of accountability in organizations. Well, compliance, of course, and the practice of ethics. You know that we call it the ACE here in the Philippines. Legitimate interest, actually. In fact, in Europe, many are saying that they would want more companies invoking that in a way because the higher standards for accountability in that sense, in a sense. When you invoke legitimate interest, there's a three-way test. I guess you would have to fulfill the purpose, the necessity, and the balance of rights. With the controller using legitimate interest as a criteria would have to again cover at least show or demonstrate that the purpose and the necessity and the balance of rights were considered before processing or when processing personal data. So here, just to segue again a bit, the amendments in the law that is being produced actually will really center on accountability. There's a provision there to actually now make formal the fines or a fine mechanism where basically infractions on accountability could be fined administratively with the amendments in place. So there might be again that shift where the administrative fines could be imposed on companies who are not being accountable, right? So these are again some of the areas that the proposed amendments will cover.
Right. So just for the benefit of our attendees, the legitimate interest exception says you don't need to get consent, but what you need to do as a controller is to see if what you are pursuing by processing the information pursues a legitimate interest, and you balance between your interest in processing the information and the harm and the protection of privacy of the individual. So we were having a discussion. I was having a discussion with Clarice, and we were saying, well, as she was said, which I thought was very intriguing. What if there was no consent anymore, and all you have to do is comply with legitimate interest? And so you force the analysis back to the controller, where the controller has to have an internal discussion about, can we do this? Do we strike a balance? You force a balance at every turn, rather than, because it's so much easier to tell your lawyer, draft a consent form, get it out there, get it signed, or get a tick box. But the legitimate interest is more of an analysis. In fact, my analogy was fair use in copyright law, because in copyright law, you can use copyrighted work without a license if it falls under fair use. So you force a legal analysis, and because it's a legal analysis, you have a tendency to ask for a license first. So in other words, the protection to the copyright owner is actually a bit more under a regime where somebody has to analyze. So in this case, if you have a legitimate interest as the instead of consent, then it might have the effect of actually providing more protection to the data subject. But I think the flip side is that it's also more expensive from a compliance standpoint, because there will have to be an internal discussion. But I think this goes back to what the chairman was talking about, is that if you're an organization interested in building trust with your customers, it's a discussion worth having internally, that every time you use data, you're building trust to your data subjects, that you're not going to harm them, that you're going to pursue their data privacy rights.
Can I comment on that briefly?
Yes, sure.
I think data protection is not an area that lends itself well to yes and no, answers, and even relying on consent is actually should not be such a ready-made solution. You also have to assess before you rely on consent whether it is actually the appropriate basis and legitimate interest. I'm not here to advocate, for the introduction of legitimate interests in all data protection laws, but I see that's a solution that many industry representatives actually advocate for, not in Philippines because it's already there, but in other laws. Indeed, you have to do an assessment, a balance, and maybe it's more costly, but that needs again to be assessed in specific circumstances, but eventually you really do the right thing. You assess whether they're at risk and how you can offset that. And nowadays we're all working from home, right? I think it would be, let's just reflect, like, did I really have a choice to work from home? Did I really have a choice to tell my employer, well, sorry, no, I won't work remotely. I want to install Zoom on my personal computer at home. I don't accept that you actually sort of track what I'm doing online, when I'm online. Actually, yeah, I'm not really comfortable with the idea, but maybe some organizations will require that. And so okay, fine. It's in the legitimate interest of an organization to put its workforce, you know, on work from home arrangement. But then it's the responsibility of the employer, of the organization to say, I've put in place measures to ensure that while you're working remotely, I've done what's right, you know, to protect your interests as individuals, as an employee. And very often we're privacy professionals, right? So we're looking at how organizations work and how we can, you know, comply and get the deal through and you know, what's needed and how do I comply? But we're also data subjects on a day-to-day basis. And I ask myself these questions all the time. Like when I'm working remotely and I'm using my personal phone, you know, okay, fine, you know, is it encrypted? Am I doing the right thing? Is it right to have two-factor authentication on a private phone when it's to access, you know, all these questions have to be considered by an employer, by an organization, and that goes way beyond collecting consent. That would be too simple, right?
That's very interesting. So I think what you're saying is that in an employer-employee context, if you're the employee, you're presented with a data consent form. Because you're the employee, it's a take it or leave it, right? So you need the job. You don't have enough bargaining power in that relationship to say no and negotiate a better deal for yourself. And actually, the Philippine Supreme Court, there were cases involving release waiver quit claims, where if I'm an employee, I am terminated, I am, the employer says, I'm going to pay you a separation pay, but you have to sign this document. And the Supreme Court has actually set aside those documents, right? Saying that understanding the power disparity between the powerful employer and the powerless employee, they've set that aside. And I wonder whether in the future, right, an employee, or maybe in the case of a borrower in a lending context, can say that the power disparity between me and the controller allows me to set aside the consent form. That should be interesting to see whether that will play out in court.
That is why, JJ, that is why I guess in the promoting the practice of ethics in privacy has a higher. I'm confident that it could have a higher take up, you know, or traction here in the Asian region, because we are more, not that we're more ethical, but really the background, Confucianism, even you know, Christianity and Catholicism, don't do unto others what you don't want to be done unto you, do no harm, the duty of care. That's why we included that again as part of the really the foundations of in exacting accountability from organization, accountability, compliance, and ethics. And as I mentioned earlier, with legitimate interest, there's a higher standard that we'll be expecting from controllers, yet not you know, not relying on terms and conditions or a privacy notice, but really when they use that as a lawful criteria, as to justify processing, and that would really entail the higher standard of demonstrating that you have considered and you've actually balanced legitimate. There's the purpose, necessity, and the balance of balancing of rights. All right, so yeah, that's a very interesting topic. I guess LIA, legitimate interest assessment,
Yes.
would be added to the lexicon, Clarice. I mean, after the PIA, so DPOs, watch out. LIA will actually be added to our vocabulary.
Thank you. So we're coming up to our time limit, and I'd like to ask just for some closing remarks, maybe ladies first, Dr. Chiro.
Well, I don't really have closing remarks. We've been talking quite long already. I think, well, I think we've made our points. I think we have to be pragmatic, not dogmatic. And very often there's too much dogma, too many dogmas in data protection, and consent is one of them. Let's be pragmatic and practical. And obviously, it's not pushing the job back to DPOs all the time, but it's to the privacy community at large too. contribute to this discussion and actually impose ourselves in the global debate that has started around COVID-19 in particular. With that, I will just close and thank you very much for the invitation. And actually, I would love to have another session, say in 6 months' time or even earlier, to reassess where we are, you know, in this situation.
We'll definitely do that. Chairman?
Thanks, JJ.
I'd like to thank Clarice first. Clarice, thank you for not giving up on our region here in Asia.
No.
You know, I was talking to a friend from Singapore, and we're also discussing the regional situation. And his observation is that practically nothing is really moving in a way that was expected. And, you know, but everything, yes, is in the doldrums. But JJ, I'd like to thank you for this opportunity. I hope you will take up Clarice's suggestion probably after 6 months. Then we can really now we can report now on the oversight that we did. Are all these contact tracing apps, did they actually work? How would be our sandbox project on the telemedicine? How did it pan out? Probably. And were we successful? So, you know, we will have an opportunity to look back. But so I will just end by saying that the COVID-19 in this global pandemic, very unfamiliar pandemic, it's not only a health crisis, right? But I view this really as a historical conjuncture for privacy practitioners, for everyone, for people like you, JJ, Clarice, and all the DPAs I have been communicating. This is a historical conjuncture. And I guess on how the DPAs basically would wield its role as an enabler and protector during this time would actually play a big part in really bringing the DPAs well towards the right trajectory that you mentioned during the start of this talk, JJ. So on how the DPAs would actually effectively navigate this period as an enabler and protector. And you there as DPOs, again, as Clarice mentioned, and the panelists mentioned that you know, your role will be more important during this time. Privacy will, I predict, would be a big differentiator as people have moved online, and as the effort to protect citizens and digital lives become more wider, there will always be the importance of the DPOs in this meeting. Thank you, JJ, and thank you, Clarice.
Thank you. Thank you, Paul. In closing, I'd like to thank both Clarice Cregero and Chairman Liboro. I think the conversation today is very important. I think there's been a lot of contribution from both our speakers to discuss, move forward, I think, a discussion that we need to have locally about what form we can have as a data privacy law evolves. And I think one of the things that we need to look at is focus more on the data subject and maybe look at data privacy more than just a compliance chore, but also as a way to advance human rights and the preservation of the dignity of the individual. And on that note, I'd like to close our Digital Transformation Thursday, our 5th. And thank you and good afternoon. Bye-bye.